Hello, Angela Princewill here. Today, in my last video, I had promised that I would create a video where I would explain what you can expect to accomplish at your court-mandated conferences. So here we are. Well, what do I mean by court-mandated conferences? I'm speaking about your case conference, your settlement conference, and trial management conferences. It's mandatory for these to happen before your matter goes from the initial inception where the application is filed to the final resolution of the matter at a trial. So today we will focus on case conferences and what the goals of a case conference is. So for most people, the first time you will be coming in front of a judge is at your case conference. If you've filed an initial application and if there is no properties involved, you've probably done your first appearance, but it would have been in front of a clerk. So your next step would be this date in front of a judge where there's a case conference to be held. And a lot of people get nervous. A lot of people don't understand the role of the judge in that at that conference. First thing is you need to understand this is your first attendance. It's not, or it's your first conference in front of a judge. It is not a trial. So the judge doesn't get to decide who's right and wrong in this situation. The goal the judge is going to try to accomplish is to see if are there any chances of settling this. You filed your initial application or you filed an answer to the application, and there's all these issues and claims by both sides. Well, the goal of a case conference is for the judge to try to see how can I get the parties to settle some issues, or are there even issues that are not in dispute? So both sides could be, or sometimes just presenting their claims and they're not really looking and saying, well, there's agreement on a few things. So at the case conference, the judge would try to bring the parties together and identify issues that are not in dispute and try to simplify the case. Is this thing blowing up beyond what it needs to be? Are there facts and issues that people are disputing that really have no bearing on the ultimate outcome of the case? And can those be sort of taken out of the picture so that the parties can focus on the issues that really matter? Another goal is usually to look at disclosure. In family court, there's a big emphasis on disclosure. It's hard for us to settle a lot of issues in family court without getting disclosure from the other side, be it disclosure to assets or income or a host of other things. So at the case conferences, if there's not been full disclosure, this is the time when the judge would speak to those issues, or if the parties are even disputing that the relevance of some disclosure. So you get the judge's input on that, and the judge would could create a timetable and say within X number of days, this needs to be done. Again, just so that the matter can be simplified and the parties can move forward with, a better sense of understanding of what are we disputing, what is the evidence that we would need, when are we going to provide this, with a view to being able to settle sooner in the process rather than later. And if there's a party that's thinking of bringing a motion, well, to backtrack on that, you need to remember that in family court, absent cases of urgency, you're not supposed to bring a motion before a case conference. So usually for parties that want to bring a motion, they're just waiting to get that case conference done. But it's a good idea to speak to the judge about the intended motion, and the judge would give some direction as to how that intended motion can proceed. I think the case conferences are fantastic for getting recommendations for the judges, and I know that's not really the purpose of my video. I just wanted to touch on these goals that I've spoken about, but you just remember that that's all that's going to happen on that day. You can get into a consent order with the other side if there's issues that are not really in dispute. If there's things that could easily be settled, then you just settle those, but it's usually done on consent. The judge at your case conference, and at all the conferences I should say, is called the case management judge. They will not be the judges sitting on your motions, absent some unusual circumstances, it can be done. But for the most part, they're not the ones going to be sitting on motions, and certainly they're not going to be the ones sitting at your trial if your matter doesn't settle. But they need to, but they're very helpful in managing the process through the court systems and trying to narrow, settle, and get people out of the court system as quickly as possible. So I hope that explains what you can expect to accomplish at a case conference. And in the form of a very quick list, I would say at a case conference, part of the goals that you can expect to accomplish is exploring chances of settling the case, trying to narrow the disputes, identifying issues that are not in dispute, simplifying the matter, going over required disclosure, setting timetables for different steps in the case, and getting direction on your case as a whole, or even or any intended motions that either party wants to bring right after the case conference. So I hope that helps. In my next video, I will talk about what you can expect to accomplish at your settlement conference.